Thank you very much. Hello, everyone. I hope you can hear me. Thank you for the floor. Greetings to everyone from Prague. So the task I have been assigned today is to report something about the Czech Republic and about our situation regarding the topic of your workshop. And I'm very, very excited about this task because the Czech Republic is not a boring jurisdiction in this respect. First, attorneys here are integral part of public debate. They comment war in Ukraine, they comment presidential elections, they comment the politics. So in this term, it's quite juicy. And second, it's definitely not a dry area of law. Recent court judgment, for example, ruled on whether and under what circumstances actually attorney can perform a strip show. So if nothing else, you should get at least this information from my presentation today. So I've decided, similar to David, I've decided to structure the presentation into three parts. First, I will explain and briefly elaborate relevant social context regarding the topic. Then I will introduce very, very briefly legal framework. And in the third part, I will talk about three selected issues that have been raised and sometimes also discussed, sometimes not that much so in the Czech Republic. So starting with the context, I think two circumstances here are important to understand how the law develops in that area. The first is post-communism. So the free profession, as we call it, the attorneys, they have quite short history in the Czech Republic. As a post-communist country, a lot of issues have not been even discussed, or at least is not yet settled. So that's the first consideration. And the second consideration, maybe related to the first one, is that there is certain disdain or at least a tension between the two main professions, the two main actors that we are talking about, judges and attorneys. So if you talk to some judges, you often hear about greedy lawyers with very narrow interest and kind of cartel style or mafia style leadership in the bar. And if you talk to attorneys, you actually hear about lazy judges who are out of touch with the normal reality. So I think this is quite important for how the law is shaped regarding the freedom of expression of attorneys. The second point, basic legal framework. I think here we follow what can be found also in other jurisdictions. We have constitution which sets the right, adds a general limiting clause. There is a freedom of expression for everyone, but it can be limited for certain reasons. Then there is a statute on advocacy, we call it, and that says that lawyer must not lower dignity of the profession. That's a statute, and based on the statute, the bar itself is allowed to adopt a ethical codex, and it adopted one, which provides more details about the specific duties of attorneys. The enforcement mechanism here is that the bar, similar to Spain, but we are less federative in this way. We have only one bar. So the bar disciplines the lawyer in the first instance. And if the lawyer wants to challenge the decision, it can be challenged in administrative justice. So that's where the tension between the two professions might get in. All right, the first issue. The first issue concerns the extent of the heightened duty to respect the dignity of the profession. And the issue is whether expressions that have very small or even no link to the exercise of the advocacy are also covered by this higher duty. So typically the cases concern things like an offensive Twitter tweet commenting only right-wing policies, or an offensive anti-Islam speech made during a public demonstration by an attorney, or an inflammatory email sent to a neighbor in a private dispute over a land. again sent by an attorney. So in all these three cases, the question is this covered by the higher duty? And the bar adopts something that I would call a monist view. And that view says you wake up as a lawyer or as an attorney and you go to the bed as an attorney. So you are attorney all the time. You need to respect the dignity of the profession all the time. What the attorneys that were prosecuted for these speeches, for these expressions, what they claim is what I would call a dualist view. So there is a professional duties and then there is a private life. And if they argue that if the act is unrelated to the exercise of the profession, it's not covered by the higher duty to respect the profession. So when this issue came to the court, as it is sometimes it is like this, the court came up with a third view, and I would call this a legalist view. So the court carefully read the statute, the Advocacy Act I was talking about, and it said that theoretically both monist and dualist views are possible, but if you read the statute, it says that the higher duty to respect the profession applies only when exercising advocacy. So the legislator made the choice, said the court, and said, so as the law stands, the dualist view is the correct one. So in all cases, it tried to establish the link to advocacy. There needs to be a link to advocacy, and the court is satisfied with pretty minor connection, but the connection must be there. So for example, the court in the neighboring dispute said, in itself, an email in a private matter is not enough, but in this case, the email was signed by a professional signature as an advocate, as an attorney. So this made the connection, and actually the heightened duty applied. The same with the Twitter. The court said, Twitter in itself, not connected to the legal profession, but here in this specific case, the attorney actually had in his bio information that he is an attorney. So again, this might allow the public to make the connection to the profession and might lower the dignity. So it was within the scope of the higher duty. So the bar exam, the bar association very much disagreed with this interpretation. It claims that it lost its tool to tackle those judges that really harm the profession, those attorneys that really harm the profession. And it actually managed to pass an amendment to the Advocacy Act, and the amendment says that the heightened duty applies mainly when attorneys are exercising advocacy. This is quite recent development. It remains entirely unclear whether it shifted us towards the monist view, so it remains to be seen. But this is one of the topics that is very much discussed in my country, in my jurisdiction. The second issue, assuming there is a connection to the legal practice, the second question is, what expressions exactly are considered against the dignity of the profession? And here I think we follow similar approach to European Court of Human Rights, similar approach to Spain, as we have just heard. And that is a balancing factor-based approach, where the case law, I listed there some factors that make it more likely to lower the dignity, and that means it's more likely to be protected, and some factors that actually make it less likely to lower dignity, and it might be protected. So less likely to lower dignity, and it's more likely to be protected, that speech, and more likely to lower dignity. So for example, the form, whether it's polite form or offensive form, similar to what was said regarding Romania, whether it was during a defense, during oral hearing, in the emotions, in the heat of passion, that is more likely to be protected. When it is premeditated, out of court, written statement, not protected. So we have this factor-based. I think this is nothing unique. What it might be unique is that very often we come across a defense of those lawyers that are accused, breaching their obligation, saying that I was only saying what client told me to say. And the courts are very dismissive, categorically dismissive, saying that your obligation is not only towards your client, but also towards some general administration of justice. So it goes broader, and you should translate at least to an acceptable manner, or you are not permitted to say everything that client says to you. All right, the third and last issue, and it is the issue of deference. And specifically, the issue is how strict should the courts be in reviewing the bar's assessment of the speech? So consider, for example, a case in which an attorney refused to serve as a court-appointed lawyer, reasoning that, I quote, only an idiot would work for such a low fee, end quote. So the bar prosecuted the attorney for that language. And when it was challenged before the court, the bar argued for deference. We are the body responsible for setting the standard, for setting the ethical duties. So the court shouldn't second guess what has crossed the line. And in our view, this is too much. You shouldn't use this language. And the court was quite dismissive here. It said, I'm not second guessing. I am only interpreting and applying the law. And it actually reversed the finding. It said idiot is still an acceptable term in this context. And in my view, the court might be too fast here and too dismissive. And I think the issue of deference really deserves more attention and more discussion. I recognize that there are some really good arguments for not granting a deference, for being strict in the review as a judge. The case involves constitutional rights. It involves the professional future of the individual. But there are also very good reasons for granting some deference. Usually deference is granted for two reasons. One is normative, and the other relates to cognitive reason. And I think both are here present. Normatively, the constitutional order make a decision that there will be some self-governance of the attorneys. It is a value. It is considered a value that they are responsible for their own profession and their own standards. So I think you should take into account what they consider acceptable and what they think that is already too much, first. And the second issue concerns the cognition. Attorneys are well positioned to judge what is too much and what is still acceptable because they know the day-to-day dilemmas of the profession. They are doing it actually, unlike judges. So from this perspective, you might again argue that it's good to defer to their judgment. So in my view, a court position might be acceptable, but it at least needs to tackle these broader constitutional questions regarding deference. So I've talked about three issues: whether you are an attorney 24/7, what are the factors for and against protecting attorney speech, and the issue of deference. Now, equipped with this information, we can return to the central question of this presentation. Can an attorney in the Czech Republic perform a strip show? And I think now you shouldn't be surprised that the bar argued that no, you are an attorney, the monist view, you are an attorney all the time, so you cannot perform strip show. The court, however, disagreed. The court said it really depends on the circumstances. If there is a link to the profession, stripping can be legitimately prohibited. If, however, there is no link to the profession, stripping is allowed. For those of you that are visual learners, what the court basically says that in the Czech Republic, as an attorney, if you want to perform a strip show, you should do it like this and not like this. I look forward to our discussion.